The crime says, hit the like. Joseph figure to 5227 says good evening everyone. Well,
Greetings and welcome to The Nature of Trust, Historical and Intellectual Roots. Before we get started, just to remind everyone this is strictly for the educational and entertainment purposes of this YouTube channel broadcast, not to be used, misconstrued, or abused for anything legal, lawful, public, private, personal, financial, business, tax, or otherwise, so please don't do this at home. That said, let's get started. So we're going to be going over equity and trust and the nature of the trust, and how one person holds property as steward, and ultimately for the benefit of another. We're going to be going over the origins, the mechanics, rights, types of trust, and the modern reach. So we'll see how this all comes together. Let's start with the origins and the roots of the trust. Trusts are peculiar to English-derived law, though. The trust is found in the United States of America, Australia, New Zealand, Canada, India, and other Commonwealth countries. But it is foreign to the civil code jurisdictions built on Napoleonic Code, civil, or the German Civil Code. Yet, perhaps not English at all. The idea surfaces earlier in the Middle Eastern Waqf, I hope I'm saying that right, providing for quasi-charitable family purposes, and in monastic orders bound to poverty. So with the monks, where they can't have any kind of personal wealth or property, this would be held in trust, so they're quasi-charitable purposes. Incubated in England and Wales into its modern form, hence we believe it is peculiar to English-derived law, but because it was incubated in English and Wales, in this concept of the Waqf and into its modern form now as a trust. It's so useful that China, Thailand, Malta, and others have since legislated to import it. Its core idea is simple: one person stewards property, ultimately for another's benefit. So today, the trust is everywhere. We have things like the will. How many wills will take effect? Commercial security. How many people secure transactions? Many. How about pension funds and unit trusts? These are bulk investments of countries like the UK. And the home, ownership of millions of homes. That's where the trust is. There are two roots that feed the English trust: one historical and one intellectual. We're going to be going over those now. Let's start with the historical root. This is great. Land, crusades, and the birth of the use. From the late 11th century, English noblemen, the great landowners under feudalism, left to fight the crusades for years at a time. Who would direct the land in their absence? Equity's answer: land could be left to the use of another while treating the absent lord as keeping the ultimate beneficial right. So we have here the nobleman departs. Absolute owner of the land. Remember, these are the English noblemen, the great landowners under the feudalism. So the nobleman departs. Absolute owner of the land, but unable to exercise his legal rights in person for years because he's on this crusade. Second is the trustee takes legal title. A trusted steward holds the common law rights to raise taxes on the land and so forth and control its use. So he's out there taxing everyone in his little fiefdom there, the steward, while the nobleman is on his little crusade. Nice. And third, the beneficiary keeps the benefit, so the lord retains the ultimate beneficial right. Equity protects it as his equitable interest. So when he comes back from his crusade, if he does, equity protects it as his equitable interest. And now, why land? The device met a problem of simultaneous claims to a single thing, and land is immovable. Unlike water poured between glasses, it cannot be mixed beyond separation. So you see here, if we wanted to split, let's say, a piece of cake, it would be pretty easy to do, or split a glass of water or a jug of water. When it comes to land, though, it can't be mixed beyond the separation. So this is a way of actually splitting the land in ways that are not physically apparent. So let's look at the evolution from land to every form of property. By the 21st century, trust attached to every kind of property. Anything English law treats as property can be held on trust. And this applies here in American law as well. So we have things like land, the original subject matter, immovable, registrable, the family home, and now we have things like tangible chattels, goods, and movables of every kind held for beneficiaries. So any kind of movable property can be transferred, things like that of every kind are held for beneficiaries. And intangible property, money, which is intangible. Remember, money is a status function. It's a speech act. It's not tangible anymore because we don't have a gold-backed currency. So it's intangible property. Shares, funds, and other complex modern assets. Why the logic creaks? The rules first built for land did not always fit these new complex assets. So trust law is developed reactively. So when two cases conflict or a principle strains against novel facts. Remember, it has been made by case since the 11th century. Its logic is bound to creak occasionally. So as we see here, this is a common law evolution. Our task: test these old principles in their modern setting and trace the judicial sleights of hand that keep them fitting. So this is our task here tonight, and we will make sure that you leave with the ability to do just this. to test the old principles in the modern setting and trace those judicial sleights of hand that keep them fitting. See how they apply, see where they don't. Let's look at the modern trust here. We got to start with this working vocabulary. There's things called the trust property, the identified property the trust concerns, also the trust fund or subject matter. In relation to a thing, when we're considering property rights, the thing is the subject matter of the rights or interests that are going to be divided in the trust. So we may refer to the trust property as a trust fund, synonymous, or we might say it's the subject matter. It might even be called the thing, but identified as trust property. Then we have the settlor, the absolute owner who creates the trust by appointing trustees. And again, this is called, in America, we usually refer to this as a grantor, also synonymous. And settlor, we're just going to jump over here to settlement, because settlor comes from settlement. It's a synonym for trust. The settlor derives from it. To settle on trust equals to declare a trust. So as we see, settlor comes from settlement, which is a synonym for trust. So the testator, trustor, whatever, it's settlor, grantor. Then we have the trustee, holds the trust fund on trust for the beneficiary. Any number, in theory, really. It's not determinable. Then we have the beneficiary, the person or persons. Remember, we're using persons here because this is not necessarily a human here. The persons for whom the fund is held, any number, in theory. So we have multiple beneficiaries as well. And then the declaration. To create a trust is to declare it. A mere intention to do so suffices. So even intent is enough, not even just the act of declaring it. But that would become the declaration regardless. To create it is to declare it by definition. A mere intention to do so is enough to declare it. So, as opposed to what it may seem, this is what it means in trust vocabulary. Now we have, back to our settlement, we saw here a synonym for trust. The settlor, that's our grantor, the absolute owner of the property that initiates the trust, is derived from it. To settle on trust is to declare a trust. So our declaration is to settle on a trust. The settlor settles on a trust. All right, on the many synonyms. Now you're going to know why we have so many synonyms and why we're going over these terms in vocabulary. Lawyers keep more than one name for the same concept, arguably to preserve the law's mystique and to leave the client suitably impressed by so much complicated terminology. So we just let you take a peek behind the curtain there. Now you see why they keep it confusing, to preserve the law's mystique. All right, now we're beyond that. Let's get to the mechanics of creation. The absolute title becomes divided title. To declare a trust, the settlor must already hold all the rights to be settled, the absolute title. One cannot deal with property in which one has no rights. So, can't split the pie if you don't have one. Before the declaration, we have an absolute title that's vested in the settlor. No legal title and equitable interest lie latent within the property. There's no albumin and yolk hidden in the egg. We can see everything is visible here when it comes to the declaration, before the declaration, I should say, as far as the property that's the absolute title being vested in that settlor. Then the act of the declaration here is declared trust. At that moment, that very moment of the declaration, that title is split. We have a legal title, which is now under the trustee, and the equitable interest, which is for the beneficiary. Both interests are brought into existence by the declaration. not unearthed from within. So we've created new interests here, new property interests, and they're split. They're property interests for the trustee and for the beneficiary. Before, all these property interests were absolutely vested in the settlor. By declaring the trust, he's divested himself of those interests, and now they are vested within the trustee as a legal title, and they're vested within the beneficiaries with the equitable interest. So the authority here, before the trust, there is simply absolute title. Legal and equitable interests arise only on declaration. So legal and equitable interests being separate only arise on declaration. These are brought into existence by the declaration. A mere intention. All right, let's look at the structure of a trust and the rights of the parties here. First, as we saw here, we have the settlor, which is the absolute owner. Let's see if we can pull in the this guy here. All right. There we go. Okay, so we have the settlor, the absolute owner. Then there's the declaration of the trust. They had their legal title and equitable interest all bound up, but now we have a transfer of the legal title to the trustee. And we have a transfer of the equitable interest. Both were owned by the settlor. It now goes to the beneficiary. So the personal rights against the trustee and proprietary rights against the trust property here are now between the trustee and the beneficiary, not the settlor. As you see, the arrows go here, and they are intertwined here. So on the declaration, the settlor's absolute title divides legal title to the trustee, equitable interest to the beneficiary. All right, let's move along. So let's, again, reading the diagram, we saw the legal title passes to the trustee, who takes all the common law rights. To the outside world, the trustee appears to be the property owner. He appears to own that property. The legal title passes to the trustee. See, so this is what the outside world sees. The equitable interest is, at this point, invisible. Land, registered at the land registry in the trustee's name. Bank account. The account and checkbook bear the trustee's name. Company shares. The share register records the trustee as owner. So even in the company, the trustee appears to the world, the outside world, I should say, as the owner. The bargain is at the heart of the trust here. Though the trustee looks like the owner, the truth is that the beneficiary holds the beneficial interest. The trustee does all the work of managing the trust property. The beneficiary takes all the benefit. As the chapters will show ahead, to be a trustee is a weighty responsibility, many duties, many obligations. Let's continue. All right, and just remind everyone, we do have the talking chat enabled, I believe. So if you have any comments, questions, or clarifications, just pipe up in the chat.
The crime says, hit the like.
And it should read it back and show it on the screen as well, so that we make sure we leave none of these concepts behind as we dig deeper into the trusts.
Audit them says, on.
All right, excellent. So we have here two people, one property. This is our division of title when we declare the trust. This is the neat trick of the trust. Two or more people hold rights in the same property at once. The common law recognizes the trustee's legal rights. Equity recognizes the beneficiary's equitable interest, the ultimate interest in the fund. Once legal title is transferred, no rights are owed to the settlor as settlor. All the beneficial interest resides within the beneficiary, and it's twofold. So let's look at these interests that reside in the beneficiary. There's proprietary rights, rights of ownership in whatever property is held on trust. The beneficiary holds the property rights in the fund, the trust fund, the trust, whether it rises or falls in value. These rights survive the insolvency of the trustee. So, the rights, even if the trustee is out of the picture, these rights are preserved. Then there's personal rights versus the trustee. Claims that compel the trustee to observe the trust terms protect the beneficiary's interest and protect the trust property. The trustee is personally liable for any loss caused by a breach of trust. So this is where the remedy is in law. Okay, there we go. And one trust, many forms, from bare trust to pension funds. One beneficiary only is a bare trust. More often, there are several, often with different rights, raising the hard question. How must the trustee act fairly among them? The answer always lies in the terms of the trust. So when you have multiple beneficiaries and the trustee shouldn't be showing favor to any. So in a simple situation here, we have an informal trust. A bank account funded by just two people may be a trust without either party realizing they created one or fixing any terms. The general law of trust simply supplies the trustee's obligations. So, general law of trust. Once that intention has been manifest, then the trust has been declared. And the general law, not your specific trust, will be the obligations on the trustee. There are certain expectations that are general. And then there's the complex, like a pension fund. Funds with thousands of members are organized as trusts, governed by elaborate trust instruments and detailed statutory and regulatory codes drafted by lawyers. And these pension funds are a major part of a lot of the financial accounting terms. There's so many, as we went over in a previous stream. Trust may be created orally in most circumstances. So the law of trust must serve a vast range of factual situations, supplying terms wherever the parties left none. So, as we see here, not only do we have synonyms, we have plenty of extra terms in case you forgot to mention any of them in your implicit trust here. So let's look at a key idea. Capacities, not people. Trust law is concerned not with people as people, but with the legal capacities in which they act. Now, this is critical right here. Their capacities, not people. So it's important to not think of individual people in these roles, but they are legal capacities in which they act. Let's take Adam, the absolute owner of the family home, who wants his children to take title after his death, perhaps to save tax. Here's one person. We have Adam. He's the absolute owner of the family home. So now we see here he wants his children to take title after death. So we have it divided up. He's a settlor. He declares the trust over the home. Then there's a trustee, holds and manages it on trust for himself for life. Then his children. And finally, the beneficiary enjoys the use of the home during his life. So each capacity is treated as a separate person. Acting as trustee, Adam may not prefer himself. He must act impartially for all the beneficiaries. So though he may be beneficiary, he needs to also act fairly for the children who are also beneficiaries. But after his death, his personal representatives act as trustees in his place. So again, it's if he's out of the picture, this trust still needs to be executed by his personal representative since he's no longer there as trustee. And this is just a very simple example here, not a recommended structure, but let's go a little deeper now. Here's one impossible structure, the limit on the idea. It's impossible when no trust arises if Adam as sole trustee, the only trustee holding on a trust for Adam as sole beneficiary, he would retain every available right. So no trust exists. He simply remains absolute owner of the property. So the children aren't in the as beneficiary, then there's no trust. Now, a valid trust in this situation could be made as a bear trust. Let's look at this bear trust. Adam appoints Bernice as sole trustee for Adam as sole beneficiary. So Adam was the grantor, he's a beneficiary, but he appointed Bernice as a sole trustee. So Adam's not the trustee. With one beneficiary, Adam, this is a bear trust. Bernice is a bear trustee, more usually a nominee. So a little British there, but nonetheless, bear trust, bear trustee, sole beneficiary, bear trust. Yet another synonym, and the wry reasons lawyers keep them. Once a client masters your jargon, your allure fades. A fresh synonym instantly rekindles their admiration, leaving them grateful to pay only a fraction of the fee your staggering intellect so clearly deserves. As esquires might say over there in Britain, the solicitors. Okay, so the multiple beneficiaries here. Let's look at the life tenant and the remainder man. Here's a common structure. On a trust for A, for life, the remainder man to B absolutely. So A on trust for A for life, remainder to B absolutely. These are proportionate rights, always depend on the terms of the trust. Absolutely here. So we have here A, the life tenant. Takes the income and use of the fund, the trust fund, during life, but with no power to dispose of it before death. So wants maximum income now, even at risk to the capital. So let's break this down a little bit here. We say the life tenant. Again, they're based on land, but this could be a trust fund. So imagine a trust fund that's got investments, and he's looking at getting maximum income from it now, even at risk to the capital, to the initial stake in this trust. So this is one aspect here where the tenant, the life tenant A here, is on trust for A for life, the remainder to B. These are beneficiaries here. Think of it like this. B's waiting on A. A wants to milk everything out of it. If it was land that has oil on it, he wants maximum income now. Drill that oil out, sell it, get all that now, even if at risk to the capital, because you're draining the capital of the land with the oil futures here. You'll have less to pull out of the ground for the remainder man after death of the life tenant. So with B, the remainder man, the remainder goes to B absolutely. He takes the capital on A's death. That would be the trust, the land, whatever it may be, the fund. Meanwhile, he can stop A and the trustee from exhausting the fund's value. So even though the wants here of maximum income, they can't exhaust the fund's value. So the wants of the remainder man, the one that's waiting for A to die, the capital is cautiously preserved. So as we see here, that's a conflict within beneficiaries that the trustee needs to be aware of. And if the trustee starts conspiring with one or the other, then that gives cause for action here. Alternatively, beneficiaries may share income equally, the trustee periodically transferring equal shares. It all depends on the terms of the trust. All right, hope that one is clear. Let's move on to one more time. There we go. The structural alternatives here. There's discretionary trusts versus powers of appointment. So let's look at these alternatives here. So we have discretionary trust. Words like shall equal must act. So if the words in the trust are, say, the trustees are obliged to apportion the fund among a class, but choose which beneficiaries receive it, applying the trust terms. So let's look at an example of this discretionary trust. My trustees shall pay $10,000 to whichever beneficiary achieves the most impressive university examination results. Okay, he shall. But then there's a power of appointment to the trustee here. May act. Trustees are not obliged, with a may here, to transfer anything. They have an ability to appoint income or capital to a class in defined circumstances if they see fit, if they have that power of appointment, as we went over before in the assignments and such, in agency, there could be different powers vested in these roles, and it's important to be aware of those. So again, the trustee in this example here of a power of appointment. Let's look at the language from the trust. The trustees may appoint. So there's a power of appointment here. May appoint $1,000 to any beneficiary whose bank account is overdrawn. Now, if let's say one of the beneficiaries is a crackhead and he's drained out the bank account, the trustee may decide not to appoint $1,000. All right, the test is the wording. Shall compels the trustee to exercise a discretion. May merely enables and leaves discretion up to the trustee. The settlor builds in flexibility for future contingencies while advisors weigh each form's tax treatment. So as you see here, especially with funds, that's where that comes in. All right, let's look at an exceptional power in the rule in Saunders versus Vardier in 1841. I believe this is in Great Britain, though. But nonetheless, these are principles that apply here. Exceptionally, beneficiaries may instruct the trustees to transfer the property to them absolutely, collapsing the trust. The rule works only on two conditions. First, the whole equitable interest. The beneficiaries must, between them, hold the entirety of the equitable interest in the fund. So it can't be a shared interest here. And two, full legal competence. They must be legally competent to act in giving the instruction. So it seems like underage minors and such wouldn't be able to have that full legal competence to collapse a trust. The deeper lesson is that beneficiaries have proprietary rights in the trust fund, not merely personal rights against the trustees. So it's not just the trustee not performing, they have proprietary rights to collapse the trust. That's interesting here. This is a rule. Let's look at the intellectual roots now that we've covered a lot of the historical roots of trust. Equity operates on conscience. The central contention here is the trust is a creation of equity that controls the legal owner's actions to prevent unconscionable conduct. Even though the modern trust is far more formalistic than the root in good conscience would suggest. A dichotomy worth holding in mind. So again, the good conscience is the root of our intellectual roots of the trust. However, there's a lot more formalistic elements now with the modern application of trusts. This dichotomy is what we're really testing here and studying now as we move to the modern interpretation of trusts and applications. Equity operates on the conscience of the owner of the legal interest, the trustee. In the case of a trust, the conscience of the legal owner requires him to carry out the purposes for which the property was vested in him, whether it was express or implied trust, or which the law imposes on him by reason of his unconscionable conduct. That's a constructive trust. So, a trust arises wherever good conscience binds an owner to recognize another's rights, whether by a consciously created express trust or by behavior the court reads as sufficient intention. So again, even unconsciously creating the trust, it still operates on conscience. So again, a trust arises wherever good conscience binds an owner to recognize another's rights. Think about this. Anytime you're in possession of another's rights, good conscience binds. So the owner in possession here, or legal title in any way, whether it's created by the express trust or by a behavior, the actions that the court reads as sufficient intention. Let's look at the taxonomy here, the nomenclature, and the three forms of the trust. Two are imposed by the courts. Only the first is the deliberate act of a settler. So this one here is the express trust, the deliberate act of a settler. This is created intentionally by the settler, the deliberate declaration of a trust. This is the voluntary creation here, the express trust. We have many episodes on express trusts on the channel and on the trust playlist, so please check those out. Next, we have the resulting trust. These are imposed by courts, imposed by the court where the equitable interest springs back to a contributor or settler. And then there's a constructive trust imposed by the court where the conscience requires a defendant to be treated as a trustee. So it's being constructed because of conscience, and it's imposed by the court still. Well, let's break these down a little bit more. So we will go over express trust in pretty good detail, but let's look at the imposed by the court type, the resulting trust. Equity supplements the ordinary law of property in two situations. Both it's the court, not the parties, that imposes the trust. So let's look at the automatic resulting trust. This is where a settler transfers legal title to trustees, but fails to identify beneficiaries. So the trust fails for uncertainty. But what of the equitable interest? It springs back to the settler. The trustee holds on resulting trust for him. Wow. So this is an automatic resulting trust. This is a settler transfers legal title to trustees but fails to identify the beneficiaries. So the trust fails for uncertainty. But the equitable interest now in this uncertainty, it springs back to the settler. So the trustee holds on the resulting trust for him. Then we have the purchase price resulting trust, where two people contribute to the purchase price. Each acquires an equitable interest in proportion to their contribution. The legal owner holds on resulting trust for both, according to those shares. Let's look at this again. Two people contribute the purchase price. Each acquires an equitable interest in proportion to their contribution. If they did 50-50 on the purchase...
It says, "Oh, praise be that the settler is still alive in that scenario."
Oh, yeah, indeed. Well, yes. All right, so good point. This is where it gets to be... again, we're looking at the fine distinctions here, and this is a great analysis right here. If that settler goes away in this automatic resulting trust, oh boy, then where does it spring back to? But the trustee is holding on to the legal title, so there's still room for remedy here somehow, somewhere. All right, and we have something tells me the state wants to jump in on that, but I digress. So with a purchase price resulting trust is where two people contribute. The proportion of their contribution will determine their equitable interest acquired, and a legal owner holds on to the resulting trust for both, according to those shares. So the legal owner, the trustee here, is going to be the one to hold on to those proportions and the make sure that division of the equitable interest is in proportion to the contributions. All right. Now let's look at the constructive trust. These are the other kind of trusts imposed by a court. It's arising by operation of law across a broad range of circumstances. Typically where a defendant deals with property knowing something that should affect her conscience. This is construed a trustee. So she's construed a trustee if it deals with property knowing, this is very important here for the knowing something that should affect her conscience. So the trustee's conscience, or a defendant here dealing with the property, we say. So a simple example. This is great. A customer hands over a $10 note. The shopkeeper, thinking it a 20, gives too much change. A customer who notices this is a constructive trustee now of the excess. Knowing of the mistake, keeping it would be unconscionable. So they are now a constructive trustee because of their knowledge. You see? So here's some other instances. A trustee's unauthorized profit. A trustee who takes a bribe. I guess you take the bribe, then you have to report it and I guess add it to the trust, but you can't act on it. Property acquired by fraud. contract to transfer property, or cohabitees' common intention in the home. So this is interesting here too. Cohabitees' common intention in the home. Like you decide you're going to live with somebody and they make an intention. Let's say one person owns a house, the other person fixes it up so it becomes livable, and they had some kind of agreement, even verbal, even not stated. It was just implied. Those actions could effectively create a constructive trust. So here's a further species: one who knowingly receives property in breach of trust or dishonestly assists a breach, though neither trustee nor beneficiary, becomes personally liable for the beneficiary's loss in the misapplication of trust property. Now look at that far reach here. This is a further species. This is though neither trustee nor beneficiary. A third party becomes liable for the beneficiary's loss in that misapplication of trust property. Powerful there. Very powerful. But as again, we're looking at these intricacies as the trust has evolved into the modern era. Let's look at this neighboring doctrine here. Proprietary estoppel. Like the trust, estoppel can grant rights and property. Its mechanism runs in 3 steps. So let's look at this proprietary estoppel. 1, assurance. In our example here, Eve assures Adam that he will acquire rights and property. Then, 2, there's detrimental reliance. Adam acts to his detriment in reliance on that assurance. So let's say he moves because he will acquire rights and a property. She assures him. Well, 3, it's estopped. Eve is estopped from denying Adam any rights in that property. So she made assurance. He did a detrimental act in his own detriment on that assurance. All those factors. So Eve is now estopped through proprietary estoppel from denying Adam any rights in that property. It's a very wide remedial discretion, though, because the court fashions whatever remedy best avoids Adam's detriment, from an absolute right in the property down to mere financial compensation. So if he just took an airline ticket out there and then she said, no, you're not here, well, then he might just get financial compensation. It matters for express trust, though. Estoppel may grant proprietary rights even where the formalities to create a trust were not met, and it looms large in the trusts of homes. Proprietary rights. Think of this. Estoppel may grant proprietary rights even where the formalities to create a trust were not met, and it looms large in the trusts of homes. So let's look at some social history now. We've gone over some of those intellectual roots. In the family settlements and the genteel class, equity's control of the trustee's conscience was developed over land, above all, the family home, then extended to money and family businesses. The judiciary prized protecting beneficiaries, whose entire livelihood was usually at stake. So you have the whole family business in there, of course. And now we talk about the genteel class, the well-bred and upper class and well-mannered, etc. Landowners in Britain. So this is kind of a vestige of the British upper class terminology. We don't use this here in America, where the drama turns on the settlement. We have Sense and Sensibility, Bleak House. Heirs left in desperate straits by their ancestors' trust that let only named relatives inherit. So we had Sense and Sensibility, the Bleak House. And then we have Pride and Prejudice. The home passes to male heirs, so women must marry well to escape a meager settlement income. So family settlements. So there you go. While the male gets the homes, the women get a meager settlement income, so they must marry well. So again, this keeps the genteel class associated with the genteel class and keeps the others out. Why the rule turned strict? family settlements and will trusts were the commonest trust before the mid 19th century. An entire genteel class depended on them. So the law built strict principles to guard beneficiaries against unscrupulous trustees bent on defrauding them. Yeah, think about that. You get all these unscrupulous trustees just drooling at the mouth over these gigantic family trusts, thinking, how much can we milk out of that and defraud them? So it seemed to have been a big problem, and that's why the rules turned strict. So let's go beyond the family now in the commercial use of trusts. And be sure you stay to the end because you have a very special surprise to make sure you leave with something as a good takeaway for being here tonight. So, in the 19th century, the imperial boom hungered for capital. Yeah, they did. Yet companies remained unlawful after the South Seas Company's collapse in 1720. The trust raised public capital instead. So we had joint stock arrangements. The members, which today we call shareholders, became partners. Of course, nowadays are more or less non-performing partners in the pursuit of commercial profit. We had unit trusts, a mutual fund in which investors pooled their money in expectation of a return. And securing transactions, a receptacle for property used in a deal between strangers. Of course, that's the term here. Strangers are not party to the transaction, so it's a deal between the strangers as a receptacle for property. Jeez. Then let's look at this example here. We have Ernest and the made-to-measure suit. Wary of an unknown tailor, Ernest pays the price to a trustee. If the suit satisfies, title in the money passes to the tailor. If not, it stays with Ernest. The trustee holds for both until the suit is completed. The trust absorbs the risk of non-performance. Wow. So in this way here, of course, the tailor has to agree about that money being held in trust. Nevertheless, if the suit satisfies who? Well, whatever requirements are set forth in that trust. And if Ernest agrees to it, if the tailor agrees to it, then I guess they would have a deal. He'll start to make the suit. Nice to have a tailor here. I guess in Britain they still got those more common. All right, here's an uneasy assimilation. Family roots, commercial realty. I'm sorry, commercial reality. Thank you. Family roots, commercial reality. This is an uneasy assimilation. As the world globalizes, commercial and financial communities have seized on the trust to secure their positions across borders. But stretching principles built for family property to complex commercial contracts is an uneasy fit, and the House of Lords has questioned whether the old rules can cope. So in Britain, they're House of Lords here. In the modern world, the trust has become a valuable device in commercial and financial dealings. It is important, if the trust is not to be rendered commercially useless, to distinguish between the basic principles of trust law and those specialist rules developed in relation to traditional trusts, whose rationale has no application to trust of quite a different kind. So this is Target Holdings versus Redferns. There's an interesting one here. It's important. If the trust is not to be rendered commercially useless, then it needs to be distinguished between the basic principles of trust law and those specialist rules developed in relation to traditional trusts. Specialist rules, trust law, whose rationale has no application to trusts of quite a different kind. Interesting. So the trust must break loose from its moorings in English social history. Yet, as we adapt it to commerce, we risk ignoring its social role, that unconscionability, in how people acquire rights in their homes, and vice versa. All right. Now, why it all matters. Let's look at proprietary rights and insolvency The distinction between proprietary and personal rights is often vital, and it bites hardest in insolvency. So the proprietary rights, a right defined, is a right identified in property. So proprietary right is identified in property, same root, proprietary property. The beneficiary owns whatever is held on trust and keeps it, even if the trustee or fellow beneficiaries become insolvent. So, in other words, if they become insolvent, creditors are coming after their assets, it can't touch the trust and the proprietary rights of the beneficiaries, especially the beneficiaries that aren't part of the insolvency. Personal rights, merely a claim to money. That's the personal right, merely a claim to money. If the defendant goes insolvent or leaves jurisdiction, there is no property to enforce against, only compensation right that is, in practice, worthless. So, I mean, it's just money that maybe the trustee's not going to get paid. I don't know. The secured creditor advantage, though. Trust property does not fall into the trustee's general estate for creditors. See this, the trust property does not fall into the trustee's general estate for creditors. It is held solely for the beneficiary. So, much trust litigation is really about insolvencies. Creditors argue a trust arose in their favor to climb from unsecured to secured. Wow. Trust arose in their favor to climb from unsecured to secured. So, interesting here, going after the trustees for the trust. Of course, we can see why that happens. All right, well, before we get into any of those little conundrums there, let's get to the best part of the presentation. Let's do the pop quiz here. We're going to have a little fun quiz here with 4 scenarios, 1 right answer. And then we're going to get to explanations of the answers too when we're done to make sure you fully understand everything that we went through here. All right, here's how we play this game. In the chat, you put the number of the question. This one will be question number 1, followed by the letter of the answer you select. If you choose to change your answer, go ahead and just put that same question number in again, followed by your changed answer, and your final answer will be the one we tally up at the end and test our knowledge. Let's get started. Question 1, can you trust yourself? Tony, who owns a vintage Mustang free and clear, oh nice, Mach 1 maybe, declares, from today I hold this car as sole trustee on trust for myself as the sole beneficiary. Nice. Under trust law, what has Tony actually accomplished? A valid bare trust with himself as nominee. B, nothing. He keeps every right, so no trust arises, and he remains absolute owner. C, a discretionary trust over the car. Or D, a transfer of legal title to an unidentified trustee. This is a pretty simple one here. Anyone have?
Lexington says capital B.
Yes, capital B. Anyone else wants to take a try?
Audit term says 1B.
All right. And we have 2 for B. Anyone else wants to pipe up on question 1? Not, we're going to question.
On the facility 6412 says 1B.
All right. Greetings and welcome, and thank you all.
Audit term says no trust arises.
Right. All right.
Joseph figure of 5227 says 1B.
Okay, so we have a good consensus here. Excellent. Let's move on. Oops.
On the facility 6412 says silly Tony.
Yeah, well, he thinks he's going to get away with nothing now. All right, so let's look at question 2. Too much change. Uh-oh. Priya buys a $5 item with a $10 bill. The cashier, mistaking it for a $50, hands back $45 instead of $5. Priya notices the error, but quietly pockets the extra $40. What is her legal position regarding that $40 that she pocketed quietly? Now, she knows about it. She notices the error. A, finders keepers. The store made the error, so she owes nothing. B, she holds the $40 on resulting trust for the cashier. C, she is a constructive trustee of the $40 because she knew of the mistake and keeping it is unconscionable. Or D, she acquires clean, equitable interest in the $40. So, too much change. I'm sure we've all, well, nowadays it's a lot less change. It's all calculated there by the computers in front of the cashiers. They don't really have to do the math anymore. But back in the day, they did, and quite frequently there would be errors either way. And
Facility 6412 says 2C.
all right, we have C.
Audit term says 2C.
Constructive trustee.
Lexinimita says after I think C may be close.
Okay, I would kind of gravitate towards C as well. Resulting trust, remember, is when there's a want of a beneficiary. A constructive trust is something where, of course, it would be unconscionable to not acknowledge it as being trustee until it can be resolved. All right, let's move along. But that's just as we're going through the quiz now. Question 3. Income now or capital later? Uh-oh. A family trust holds a stock portfolio for Grandma Ruth for life. The remainder to grandson Ethan. Absolutely. Ruth, definitely Grandma's name. Ruth pushes for aggressive, high dividend bets. Ethan wants steady, capital preserving holdings. Which best describes their positions? A. Ruth is the life tenant, rationally favoring income now, even at risk to capital. Ethan is the remainder man, favoring preservation. He hoped Grandma doesn't squander all the profits with high risk gambling. B. Ruth is the remainderman. Ethan is the life tenant. C. Both hold identical interests, so there is no real conflict. Or D. Ethan may invoke Saunders versus Vadier to cash out immediately with no need to involve Ruth. So the Saunders versus Vadier was when there's to prevent the exhaustion of the entire trust fund. So if Grandma's out there gambling at the
Facility 6412 says 3D.
All right, 3D. Now that's because he pushes for aggressive high dividend bets. We didn't say here she necessarily extinguished the trust though. So again,
audit term says 3D.
All right, 3D. So I just want to say that the fact that Ethan wants steady capital.
Lexinimita says capital C.
So there's no conflict. All right. Maybe we're not getting clear on this one here, but the fact that Ruth pushes for aggressive high dividend bets, but Ethan wants steady capital preserving holdings. Neither here have we shown that there's a real risk to the trust holding in general. Just that they have preferences here. And by preferences, does Ethan really have a cause here? Is it really at risk of being extinguished? Or is it just a fear? They both have identical interests, but is there a conflict here when, remember...
Facility 6412 says capital A.
All right, so we have a capital A. All right, anyone else for question 3? Question...
Joseph figure 5227 says 3B.
All right, 3B. Interesting. So the life tenant is the one that is going to die and is going to go to the remainderman. So I guess, if Ethan died first, that would really suck for Grandma. But as far as remainderman, let's see here. The remainder goes to the grandson, it says. So I'd almost construe this language here as remainderman. Absolutely. Okay, let's go on to question 4. Final question here is when the trustee goes broke. Oh boy, the insolvency here. Marcus wires $80,000 to an escrow agent to hold in trust for him pending a home purchase. Before the closing, the agent files for bankruptcy owing dozens of creditors. Where does Marcus stand? Oh Lord. A. Unsecured creditor likely to recover only pennies on the dollar. B. Out of luck. The agent held legal title, so the money's gone. C. One of many creditors splitting the 80,000 equally. Or D. A secured creditor. His proprietary interest keeps the $80,000 out of the general estate held solely for him. So, is he a secured creditor because of his proprietary interest? Is he out of luck? Is he one?
Facility 6412 says 4D.
Okay, we have 4D. Is he an unsecured creditor or a secured creditor? So what is securing this? He wires $80,000 to hold in trust for him. So the $80,000 is in trust. Agent files for bankruptcy, owes dozens of creditors. But what about Marcus? Is he going to be one of those creditors that are owed to this escrow agent, but is being held in trust? So can the bankruptcy touch that trust? Is it part of Marcus's estate? So if it's part of his estate, the escrow agent's estate, then Marcus is just one of the many creditors. Would he be out of luck because the agent had a legal title, is held in trust? Is he an unsecured creditor, likely only to recover pennies on the dollar? Or is he a secured creditor? His proprietary interest keeps the $80,000 out of the general estate held solely for him. Anyone else? This is a difficult one here. I think we have one answer for 4 so far. Anyone else wants to take a chance at question 4? So
Nimrita says number 4 is or D.
A or D. It's A, B, C, or D, but only one is correct. So we got to commit to one, and then we can move on to the answer slides. I'm going to wait here to get some answers in. We're going to look this, I'm going to talk it over while we wait for the answers. So Marcus, he wires $80,000 to an escrow agent, and that's being held in trust for him. So the escrow, he's wired it to the escrow agent to hold in trust. Escrow agent now is the trust, is holding for him, Marcus, as a beneficiary, pending a home purchase. Okay. But before the closing, so he's holding it. During this time of him holding it, Marcus goes to close on the house, but find out the money's not there. The agent files for bankruptcy, owing dozens of creditors. So now, where's Marcus stand to recover his $80,000? Is he an unsecured creditor, likely to recover pennies on the dollar? Is he out of luck because the agent held legal title, so the money is gone? Is it C, one of the many creditors now of the estate, splitting the $80,000 equally? Or is
it a figure of 5,227 says 4D?
All right, so we got 4D. We have a couple for 4D. A secured creditor, his property interest keeps the $80,000 out of the general estate, held solely for him. All right, all our answers are in for question 4. Everyone that wanted to take a stab at this one here. All right, let's get on to the answers.
Nimrita says 4D.
Okay, thank you. So we have full commitment now. Let's move on to the answers. All right, come on. What's going on? Hang on a second. It's giving me a hard time here. There we go. All right, hang on a second. Well, this give me an issue here. The suspense to get to the answer slide. Oh, there we go. Okay, answers 1. Tony, trying to make himself all 3 roles. What happens when he does this? Nothing. B is the correct answer. He keeps every right. So no trust arises, and he remains the absolute owner. Why? Because a sole trustee, who is the sole beneficiary, holds every available right. So, of course, no trust arises, no division of title, no trust forms. Had Tony named someone else as a nominee or trustee, as we'd say here in America, it would have worked. So, yes, 1B was the correct answer. I think we all get this one correct. Yep, silly Tony for sure. All right. Let's get on to question 2. Priya buys a $5 item with a 10. Cashier thinks it's a 50, hands her back 45. This cashier is going to have a very short career at this shop. Priya notices the error but quietly pockets it. What's her legal position regarding that $40? And the correct answer is C. She's a constructive trustee of the $40 because she knew this and she knew the mistake, and keeping that.
Nimrita says in tribe we trust.
Thank you. So yes, indeed, she was unconscionable if she keeps it without notifying the cashier, and until she does, she's the constructive trustee. So in this respect here, you got to think it's almost a duty to report. And yes, 2C. I think we all get this one, and yeah, C was close enough. So we'll all go for 2C. I think we all get that one right. Excellent. Let's move on to the next one. Question 3. Family trust holds a stock portfolio for Grandma Ruth for life, the remainder to Ethan, grandson. Absolutely. Ruth, the one that's grandma, she's pushing. Grandma really likes some high dividend bets, but Ethan wants steady capital preserving holdings, so there'll be something for him when she dies. What best describes her positions? And the correct answer is A. Ruth is a life tenant, rationally favoring income now, even at risk to capital. And Ethan is remainderman, favoring the preservation. And hang on a second, was that the right wording on that question? Wait a second here. Oops. There we go. Oops. Oh, there it was. I was on there. Okay, there it is. Yes. All right. So I want to make sure that wording was right. Don't want to mislead anyone. So Ruth is the life tenant, rationally favoring income now, even at risk to capital. Ethan is remainderman, favoring preservation. So as a life tenant, she takes income for her life and wants it maximized. She doesn't care if she's dead. The remainder goes to Ethan after she's dead. And he takes the capital later. Because he gets it later, he wants it preserved. He doesn't want her to lose in those high dividend bets. This is the classic conflict, and Saunders versus Vadia needs all beneficiaries acting together for Ethan to act like that. Since it's not in that kind of a situation, then it's really just a conflict of interest here that doesn't affect the trust per se. So I think, let's see here, what do we get for this? Yeah, question 3 was actually A. As a life tenant, this is what they prefer. So again, this is a little tricky one here.
Nimrita says him is remainderment. A really real word, reminds me of remnant.
Yeah, it's the remainder man, not remainderment. It's remainder man. So it's the remainder man as to one remaining at the end of the death. Someone died and someone's remaining. So this is how the term. Again, these are more British, and again, since we're looking at the historical roots, and so many of these terms are synonymous for the very reason we read earlier. Left a lot of the British terminology here because that was the origin text had in it. All right, nonetheless, we see here that 3 was a tricky question. I don't think any of us got this one right here. Yes, someone got it right. That was, there you go, for 3. All right, let's move along here. So one wise lady got this one right, but this was a tricky one. All right, let's go on to question 4. Marcus wires $80,000 to an escrow agent to hold in trust for him pending a home purchase. So before the closing, the agent files bankruptcy. Where does Marcus stand? And the correct answer is D. He's a secured creditor. His proprietary interest keeps the $80,000 out of the general estate, held solely for him. Why? A beneficiary's proprietary right survives the trustee's insolvency. So trust property never joins the pool for general creditors. Marcus is effectively
on facility 6,412 says first clean sweep 4 out of 4A.
Yes, indeed. That earns the trophy for sure on that one. Congratulations. Yes, and this has been a difficult one here because we did get in a lot of detail. I will say that I did have this presentation yesterday. I've kind of moved it to the members only side, but it was, I found it just wasn't, first of all, I don't think notifications went out, nobody participated. But second, I found that it could be a little bit more, user friendly or more interesting to keep the attention for something of such a detailed analysis here of the nature of trust. And it is a little bit off the beaten path of where most people are covering the formalities of trust to look at the real intentions of how it was made, why it's persisted.
Links and Nimrita says great job on Facility 6412.
Yeah, yes, indeed. This is, again, this is something.
On Facility 6412 says I'm so proud, haha.
Well, again, this is something where I'm very appreciative of those who do participate here because, again, there is something to apply in our day-to-day lives. We see with these trusts, whether we realize it or not, consciously, unconsciously, verbally, written, expressed, implied. There's many different ways that trusts form in our day-to-day lives, even though they started out as something to from the Crusades, actually, believe it or not, because those people that held the land, when they wanted to leave, there was no one to make sure the taxes were collected, the land was maintained or not overrun or taken over with adverse possession. So the trusts were there to protect those interests. To this day now, we've seen it transform not just to...
On Facility 6412 says I'm writing my revocable trust this weekend.
All right, excellent. Well, maybe we'll do one on the revocable, irrevocable, and some of the little details between those and distinctions. If anyone wants to make any suggestions for those. I have a lot more topics on trust. Trusts go very deep in very many directions, so there's a lot of ways we could attack this one. I kind of like the general overlook to give people more familiarity with the elements of trust and how they apply, just to build the awareness. And then, of course, the self-guided direction there into any details of specific trusts that might apply for their needs. And this is where it all starts, understanding the nature of the trust. So I hope you all enjoyed this, going over the historical and the intellectual roots of the nature of trust.
Audit them says revocable versus express. On the Facility 6412 says, can't find your email address, Mr. Tribe.
Okay, yes, I'm going to double check in the community. It should have been in a post there, but you know how those things go. I'm going to put a post back in the members only community there so we can have that one accessible for those to reach out. And revocable versus irrevocable trusts. One distinction I'd just say here is realize that
on Facility 6412 says cool.
All right. Revocable trusts will actually be something where if it's found by a court, there's issues with the trust or it's within the reach of a cause of action that they can order it to be revoked. Irrevocable trusts, that wouldn't happen. So depending on the uses, I think it would behoove one to really look at the distinctions and make a clean discernment whether revocable or irrevocable would apply. But in some cases, depending on how it needs to be maintained, revocable might be useful. So we'll look into this a little bit deeper there. I'll see if I can put something together to really clarify.
Lex and Nimrita says groovy show. Peace out to the tribe and all.
Yes, indeed. All right. Well, on that note, I'd like to thank you all for being here and hope to see you all on the next one. Peace out.